Hello, and welcome to Collyer Bristow's Financial and Commercial Litigation podcast. I'm Robin Henry. I'm the head of dispute resolution here. I've got here with me David Lascelles, barrister at Littleton Chambers. Perhaps, David, you'd like to say hello and introduce yourself?
Hello, everyone. I'm a barrister who specialises in company law at Littleton Chambers and then general commercial disputes, including a lot of share sale disputes, which I know is one of the things we're going to talk about today.
Exactly, and that's one of the reasons why I've invited you on the podcast today. What we're going to be talking about is notification of claims in share purchase agreements. And you might think that's a bit of a dry subject, but I can promise you one thing, that it's going to be a world exclusive. I don't think there's going to be any other podcasts which are talking about notification of claims clauses. But I think it does raise some very interesting issues for commercial transactions and how things are dealt with and what the sort of legal risks are either during the commercial transaction or afterwards if there is a potential claim. So what we're going to do is we're going to look at a case called short title Drax against Scottish Power, which was there was a Court of Appeal decision recently. Perhaps you could give us some of the background facts of the case.
Yes, so this is a fight between two very large power companies, Drax and Scottish Power. As you say, Robin, we're talking about here the purchase of a company, the target of the purchase owned a site in Kent, which Drax wanted to buy so that they could build a ginormous power station. And a lot of negotiations, both parties represented by experienced, sophisticated law firms, 700 odd million pound transaction. And one of the key parts of this transaction, given the aim was to enable Drax to build a power station on this site in Kent, was going to be the ability to connect the power station to the national grid.
Yep.
Now,
Fundamental.
Luckily, as it appeared in advance of this sale, the site of land was next to another piece of land that already had a power station on it. And so there was a ready connection, in theory, available for the power station once built. And Scottish Power said and believed that it had an option agreement that would allow cables to be laid from the new power station once built to the national grid, so that once Drax had got the power station built, connection should be straightforward. So that's how things appeared at the date of the sale. Of course, this option agreement, the ability to lay the cables, was a really important part of the transaction. And as part of the sale, Scottish Power agreed that the company would have the benefit of this option, and it warranted. It said that the company did have the benefit of the option. Unfortunately, that was mistaken. The option hadn't validly been assigned to the target company that was bought. The warranty was false, and Drax found itself with the site, but not with the option to lay cables to connect to the national grid.
So there they are. They've had a huge commercial transaction, but they've made a mistake, and there's this crucial element: they don't have the right to lay cables between one power station and the national grid. And it just reminds me of when I've been doing commercial transactions as an insolvency lawyer. I used to do contentious and non-contentious transactions. That's why there's always, as a lawyer, there's a feeling of dread when everybody signs up at the completion meetings. Everybody else is doing high fives and enjoying themselves. And me as a lawyer, certainly I think must be a common feeling, just thinking, I just hope there's nothing wrong in there. There's no mistakes, because now it's signed, it's done and dusted, and everything's set in stone, and it can now be poured over for years by people, including the Court of Appeal. So that's what you don't want to happen. But that's what happened in this case. Let's talk about what then happened. Drax then found out quite soon after completion that they didn't have the right to lay the cable. And what was their option then under the contract? They had this notification of claims clause.
They did. So they had a number of potential routes under the contract, and we're going to talk today about the breach of warranty route, as that's the most interesting part of the decision. And as we've mentioned, they had a warranty in the sale agreement, which in effect meant that Scottish Power was saying there is this option agreement, it's there, it's valid. And so the first port of call for Drax was a claim for breach of the warranties. But as is very common in these types of transaction, there were limitation provisions. So there were provisions which meant that if you were going to bring a claim for breach of warranty, it had to be notified within a particular time period and with particular details. And so that was something which Drax had to ensure that it complied with. It had to comply with the letter of these notification provisions in order to be able to bring its claims. Now, there was a lot of correspondence after the sale. So I think it was about 2 years of correspondence, wasn't it?
Yeah. I think it was 30 months they were allowed. They had the time between the completion and when they had to serve the notification of claim.
So when did they do it?
They did it on the last day. Of course, they did it on the last day of the 30th of June, 2021, the last day they could possibly do it. These notification of claims clauses are very common, and it's all part of the allocation of risk between the parties. It's very heavily negotiated, and it's basically saying, usually the limitation period would be 6 years. That's a basic starting point. But parties are free to change that risk. The purchaser may want to be allowed 6 years, but the seller wants to draw a line under the transaction and will say, no, you have to. If you've got a claim against us, you're going to have to do it in a shorter period of time. And as you say, there were various claims they had, and there were various time limits for those different claims. These are essentially limitation clauses, aren't they? They're limiting the purchaser's limiting its own rights to make a claim, so it can put whatever it wants in that clause, or what is agreed between the parties. And so that's the sort of context of where we are. What then happened when they put this notice of claim in, and Scottish Power objected to it, didn't it? They said it's not a valid notice of claim.
Yes, that's right. So very commonly what happens with these clauses is a notice of claim has to be put in within a certain time period so that the parties know at the end of that time period where they stand. There's usually exceptions for fraud and the like. So it's perfectly possible to bring claims where there's been wrongful concealment or fraud in most cases, but usually where both parties have just been acting commercially in good faith, a line is drawn at a particular point in time in terms of, first of all, notification of claims, and then the bringing on of proceedings themselves. So usually what you have is a 6-month period, a 9-month period, 12-month period for negotiation between the parties, but a period during which a claim has to be brought after the notice has been filed. So what we have here is, first of all, the notice goes in, and we'll talk in a second about what was in the notice. Then Drax issued proceedings in line with the time limit under the clause, so within 6 months. And then what Scottish Power say is this: they say, your notice isn't valid. The notice had to deal with various matters. Your notice failed to do so, and therefore your claim is bad. Your claim should be struck out. That should be the end of the proceedings. And if the Scottish Power were right about the deficiencies in the notice, if it didn't comply with the clause, then indeed that would have been the end of the proceedings. So very quick, easy win without any need for all the expense. And we could be talking readily a 7-figure sum spent on each side in terms of proceedings over this sort of thing. But all that would be brought to a swift end, and no need for trial, no need for witnesses in the box, no need for lengthy, expensive, troublesome dealing with lawyers, just to draw a complete line under this.
So what was wrong? What did Scottish Power say was wrong with the way in which the claim had been formulated? Because Drax had said, well, it said our loss is that the company is going to have to pay the owner of the land over which the cables are going to be laid. They're going to have to pay them, and that's going to cost it's about £8 million, I think was their estimate. And then they said Drax is responsible for that cost, and that's how we formulate the claim. So, and they then, when they issued proceedings, they said the same thing. But Scottish Power said, well, that's not right. So what should they have said?
Yes, that's exactly it. So, and we should say that all the way through this, Drax and Scottish Power had solicitors. They had no doubt barristers when they came to issue the claim. So the claim was being put on this footing that effectively Drax was able to recover the amount that the target company would suffer, as you say, the cost of getting a new right of way over the land, the cost of laying longer cable, because the owner of the land was now saying it wouldn't allow the original route to be used for the cable, even if it was prepared to grant a new option. And the whole way through, up the Scottish Power, putting in its defence, Drax was saying this is the amount we're entitled to claim, effectively the loss for the target company. Now, that is the wrong way of going about claiming loss in this type of dispute. It's so commonly done. And we see these arguments being made time and again.
Loads of lawyers involved in this. So, another, on the face of another big mistake that's being made here. And also, but Scottish Power's lawyers didn't immediately say, what are you talking about? I think in the correspondence, they must have raised it in that way.
I think that's right. And so you wonder whether that was tactical or not. But you're quite right. This time we've now got Drax's lawyers screwing up. So originally we had Scottish Power mucking things up in terms of the validity of the option agreement. And then we have now, when it comes to litigation, Drax and all their lawyers screwing up. And so now Scottish Power is seeking to take advantage of that. What should have happened is this. They should have put down how much the value of the shares have been affected by the fact that the warranty wasn't true. So the traditional way of measuring loss on a share sale dispute is to say how much of the shares worth if the warranty is true. Often that's just the purchase price, because of course the parties have done a deal arm's length at the purchase price on the basis that the warranties are true. So often that will form the starting point for a damages calculation. And then you've got to work out how much is the company actually worth now that we've discovered this fault, the fact that it hasn't got the option agreement. And you work out the difference between the two, and that's how much you're entitled to claim, the difference between the warranty true and the warranty false. Now, often that's not going to be the same, is it, as the actual cost to the target company. The reason for that is that when companies are valued, at least if it's a business that's a going concern, it's generating earnings, it's generating profits. The usual way in which a company is valued is by looking at its earnings and applying a multiple to take into account the expectations that those earnings are going to remain the same or going to increase over a number of years. And so when you have a one-off hit, the cost of a license agreement, the extra cost of the laying of more cables, that doesn't tend to have a pound for pound impact on the value of the company. And it's interesting, there's a sort of a throwaway line almost in the Court of Appeal where they note that in actual fact what had happened was that Drax had sold this company on, and as far as they could work out, it didn't seem to have impacted the value of the company itself.
Yeah, they'd already, even when these proceedings had happened, Drax had already sold the company on. And as you say, in that transaction, seemed to have noticed anything about the cables and didn't take or apply a discount for it.
That may be one of the reasons why the claim was formulated in this way, because Drax felt that it could recover more by pointing to the target company's loss rather than its own loss. Because it may well be that its own loss was much less significant, if any. But in any event, it's the wrong way of going about measuring loss. The correct way is to look at this warranty false and warranty true comparison. And indeed, when it got to court, when Scottish Power raised these objections in its defence, Drax didn't seek to uphold its original measure of loss. It accepted that it had got it wrong, and it applied to amend its particulars of claim in order to claim the correct measure of loss, this warranty true versus warranty false measure.
But interestingly, they said, and evidence of that loss is the amount that the company is going to have to pay to lay the cables. So I think they're trying to have it both ways, weren't they? They were trying to say, this is actually our loss, is the cost to the company, but it's actually going to be formulated in the way of the value of the shares.
Yes, I think that's right. So I think they were trying to square the circle, really, weren't they?
Yeah.
At that stage. And you can see how, I mean, I think most likely the impact on the shares, how much this warranty being false mattered to Drax as the owner of the shares, part of that will have been the additional cost to the target company. That inevitably will have been relevant when you're calculating loss, but it really won't have been the whole picture. No. And what you really need in this situation, at least by the time you get to trial, and we can talk tactics a bit later on in the podcast, but what you really need is an accountant to come in and to look at how the company's valued and to look at what's gone wrong and to work out what is the impact on the share value.
And it's not a straightforward question at all, is it? It really does need expert evidence to work out that amount. Okay, so Scottish Power have objected to the notice of claim, saying that you formulated claim in the wrong way. What does the judge at first instance decide?
So at first instance, it's in the Circuit Commercial Court in London, so part of the High Court in London. The judge at first instance, Simon Burt, KC, decides that Scottish Power are right, that the claim hasn't been properly notified. And as with all these cases, the first port of call is you've got to look at the SPA and see exactly what it is that's said in terms of what's got to be notified. And here what it says is that there's got to be a statement when giving this notice of warranty claim in reasonable detail the nature of the claim and the amount claimed, detailing the buyer's calculation of the loss thereby alleged to have been suffered. And what Simon Burt said was, what we need here is we need in reasonable detail the nature of the claim, and we need in reasonable detail the amount claimed. We've got a 9-page professionally drafted notice of warranty here, and yes, it sets out the essence of the claim in terms of liability. But because instead of claiming Drax's loss, it's really looking at the target's loss. He said that's not the proper measure of loss. That much is common ground, and as a result, it doesn't satisfy the requirement to specify the nature of the claim, and it doesn't satisfy the requirement to specify in reasonable detail the amount claimed because you're claiming the wrong loss. So he said, therefore, the notification isn't valid.
Yeah.
End of the claim.
Yeah.
Now, no doubt that would have left the former lawyers by this time feeling pretty miserable about the position. Drax itself feeling pretty miserable about the position, and Scottish Power rubbing their hands because they have sold a company that was worth probably a fair amount less than that which they got for it,
That's
and
right.
they've got away scot-free.
They screwed up providing the easement to lay the cables, and they got away. Drax has failed in its claim on what you perfectly well say is a technicality. They have got away with it. So Drax appeal. We'll come back to afterwards as to what we think of the relevant decisions in the first instance, but they appeal to and got to appeal, look at it, and they then decide and they allow Drax's appeal. So tell us why they changed or came up with a different view.
You could see that the Court of Appeal had considerable sympathy here with Drax. As I say, there was a 9-page letter that was drafted. This followed a couple of years' worth of correspondence between solicitors. Everybody knew what the problem was here, which was that the option agreement had not been validly assigned. It wasn't in existence anymore, and the result was that a new option agreement was needed, and cables might have to run over a longer path. And that much was absolutely obvious to everybody involved. And the cost of it, actually to the target company, as we say, was set out in the notice of claim. And what the Court of Appeal said is these aren't meant to be tripwires. This isn't meant to be a field day for lawyers or a windfall for the seller. What's meant to happen in relation to these clauses is you look at the commercial purpose. Really, what's been expected here is that Scottish Power need to know that a claim is coming. They need to have an idea of what's going to be said in relation to the claim. And what they know here is they're going to face a claim. They know the basis of the claim. They know that they can go and get legal advice. The lawyers can tell them whether or not this has been put forward on the correct basis. They can dispute it if they want. They can get their own accountancy advice if they want about the likely measure of loss here. They know enough, and it wouldn't be fair in this situation to say that there hadn't been a notification. It satisfied the commercial purpose of the claim.
Yeah, and crucially, they said that they've put forward this claim, and they have put forward their calculation of loss, which they believe in. It may be, legally inaccurate or not the right way of doing it, but they did it in good faith. No one was accusing them of acting in bad faith. And I think that was one of the crucial things that the Court of Appeal said, had to be there for them to agree with that.
That's very true. And the reason I think the Court of Appeal said that was because they really centered on part of the clause, part of this notification clause, which said that the notification had to detail the buyer's calculation of the loss. And in many ways, they centered on that to the exclusion of the earlier parts. They really focused on the fact that it had to detail the buyer's calculation of the loss. And they said this was the buyer's calculation of the loss.
Yeah.
If it hadn't been, so if the buyer had said, this is my calculation of the loss, and that was not true, it wasn't its calculation, it hadn't been acting in good faith, then the clause wouldn't have been satisfied. They wouldn't have provided their calculation of the loss. But the Court of Appeal said no one's contending that there's any lack of good faith here. No one's saying that it's dishonest or bad faith or anything, and therefore it satisfies the requirement. I don't know what you think of that. Do you think it should be the limit of this, that as long as it's in good faith, that's enough?
I'm kind of with the Court of Appeal mostly on this, but I can see that one of the reasons why there might be a concern is that, okay, so you've entered into this commercial transaction, you've given this notification of claim clause, and you say you're only allowed, 2 years or something to make a claim. That time limit's coming up. The buyer's getting not sure whether they've got a claim. And so they put in a bogus claim. They put in a specious claim about something that they don't really believe in, but they put in a claim. And that allows them to then issue proceedings if they want to. Now, I can see that that's someone acting in bad faith. The problem with that is that always obvious? Whether or not somebody is acting in good faith or bad faith is not an easy thing always to discover. So as being the only protection against a party seeking to abuse the notification of claim clauses, I think it does introduce an element of risk, whereas the first instance decision was very much, you've got to get it right first time. And if you don't get it right first time, that's it. You've agreed to these terms. I think generally I'm mostly with the Court of Appeal in that in this situation, they've been essentially arguing about, they knew perfectly well, Scottish Power knew perfectly well it was a claim. They knew what the claim was about. And for them to get the claim dismissed because the formulation of the value of the claim, which would then be dealt with in proceedings, I think it was certainly harsh on Drax in the situation. What do you think?
I have some sympathy with that. I can see how, if you're there as the court, there's an obvious problem here. The problem in terms of the underlying dispute, the problem is Scottish Power's fault. This is obviously a key part of the transaction, that this option agreement be in place, and it wasn't. And the result of that is that Drax has bought a company which didn't have a key license in place, didn't have a key right of way in place. And so you can see how, standing back, if you're the court, you would have a reluctance to allow a technicality such as this to give Scottish Power what effectively is a windfall, and what will then just trigger professional negligence proceedings, presumably by Drax against its solicitors, and you end up with a proxy war. Effectively, you end up with it being fought almost between the wrong parties, when it should really be a Drax Scottish Power dispute. It ends up being a Drax and their solicitors professional negligence dispute. So from that perspective, I can see where the Court of Appeal is coming from. I think where I part company with the Court of Appeal and have more sympathy with the judge is what they say about the commercial purpose of this clause. In effect, what they say is that there's no commercial purpose served by requiring Drax to put down a proper measure of loss.
It's the Court of Appeal.
It's the Court of Appeal.
Yeah.
They say the commercial purpose of this clause is that Scottish Power no claims being bought. Scottish Power no claims being bought.
Yeah. And
so the commercial purpose is satisfied. We don't need to have the correct measure of loss. I think that's a little bit glib, if I may say so. I think what Simon Burt said, and I think this ties in more with what some other commercial court judges have been saying, is that when you're looking at this type of notice, you as the recipient, here Scottish Power, need to know what's been said about the quantum of the claim. It's a key part of this type of dispute. What is the true quantum of the claim? You need to know that so that you can take advice on it, you can attack it, you can make provision in your accounts for it, and indeed then settle it if you want. And yes, Scottish Power could themselves do all the running in that respect. It seems to be what the Court of Appeal is saying. You've got enough here that you can then do the running to get to the bottom of your potential liability. And to an extent, I think that's probably right. They could do the running. My concern is, why should they be the one who has to do all that running when the clause requires Drax to say in reasonable detail how much it's claiming? How can it be in reasonable detail when you haven't stated how much your claim is actually worth?
I'm not sure about that in this particular situation, because you can argue that Drax and Drax's lawyers should have formulated the value of the claim in the correct way. But is it so obvious that they should have done that when they then went ahead, issued proceedings, and the original particulars of claim said exactly the same thing, unless they knew what they were doing and it was a tactical thing. But it seems to me that I don't think formulating the value of the claim necessarily would have had any material impact on Scottish Power, because they've been notified of a claim. They have to instruct lawyers to deal with it. They have to work out, even if being formulated in the right way, they would have had to have defended it. They would then have been able to look at it and go, well, we're going to defend it on the basis that that's not the right formulation of the claim.
I'm a bit skeptical of that. For example, we have a situation here where actually, although there is a one-off cost, it has a fairly limited impact on the value of the company that's being bought, which, as I said, there's some evidence for in terms of that it appears to have been sold without this lack of option being a particularly significant, or there was no evidence of it being a significant factor at all in the value of the company when it had been sold. If we'd ended up with a situation where Drax had said to Scottish Power, for example, we believe that the impact of this on the value of the shares is 1 million or 2 million, it may well be that this would never have seen the light of day in terms of proceedings. It may well be that had they adopted the correct measure of loss, and that had indicated, in fact, they were talking about a significantly lower potential claim, then the matter could have been much more readily resolved.
I think it comes back to this issue of good faith and bad faith. If Drax had done that deliberately, they didn't believe that was their loss was actually 1 million, and they've inflated it to 8 million in order to actually, get a settlement, maybe 2 million or something, then I can understand that. But I think we're back to that. From my point of view, we're back to that issue of good faith and bad faith, and how, whether that's sufficient protection for abuse, against abuse in these kind of clauses.
Yeah, I think that's right. I mean, I think it's probably not sufficient protection. On the other hand, I know when I get one of these cases, when I'm acting for the seller, the first thing you always do is look at the notification if you're involved just at the litigation stage, and you look to pick holes in it, and you look to take advantage of technicalities. And although that can be quite a fun exercise, relatively speaking, quite a fun exercise as someone who comes in at that stage, it does have the feeling that you're effectively setting tripwires, doesn't it? And
yes,
and it doesn't. It's fun in part because you're helping your client get out of what will otherwise potentially be, in some cases, a very significant liability on a technicality. And I can understand how people say these it shouldn't really be the solution to these type of cases, at least where it's not abundantly clear that the parties are themselves trying to set out this type of tripwire.
So just sort of rounding things up, perhaps, looking at the Court of Appeal decision, how important do you think that is? Do you think it sets a precedent generally, or is it something that really is fact specific and depending on the particular wording of the clauses that we're talking about here?
So I think it is key to look at the wording of the individual clauses, certainly, and the cases again and again stress that. But I do think that this is a really important case. I do think we're going to see this pushed out time and again over the next few years in relation to these type of disputes, because it represents an incredibly buyer-friendly answer to these type of disputes. It represents an easy way for buyers to be able to satisfy notification clauses. So I think we're going to see in many of these cases over the next few years, and you do get a lot of these notification of claim disputes. We're going to see this case cited, and we're going to see buyers relying on it and saying that court should look beyond any technical issues with their notices.
Wouldn't a buyer or the parties to future transactions look at this and go, well, we're just going to have to tighten up the wording? Okay, so it wasn't enough that in this case, it said it had to be reasonable details provided in relation to the claim. We're going to set out in, really fine detail exactly what the clause is going to have to say. And doesn't that get round it?
So the Court of Appeals say in Drax that it's up to the parties. So yes, they can do that. They can set out whatever requirements they want in terms of the detail of the notice of claim. And once that's set out, the court will give effect to it. And as I mentioned, Sam Casey's decision was in line with other first instance decisions. There's a case back in 2017, a case called Zayo and Engler in the commercial court, a particularly harsh decision in many respects, but that clause had required notification in reasonable detail of the estimated loss that had been suffered. And the commercial court in that case said that wouldn't be satisfied if the amount wasn't calculated on the correct basis. They said that wouldn't be a reasonable estimate if you've got the legal basis for the claim wrong. Now, if a buyer, seller want to agree, prepared to agree, stronger terms going even beyond that, which we had in Zayo, going beyond that, which we've got here in Drax, they could do so.
Yeah.
And you're right, we may see that. There's going to be the to and the fro there, isn't there? There's going to be the push and the pull in the negotiation. So that's obviously what goes into the SPA has to be agreed between the parties.
I think that's what's going to happen next. Is lawyers are going to take this, transactional lawyers are going to take this, and they're going to look at notification of claims clauses and factor in this particular additional issue as to how much information they're going to have to include in these clauses. And it's, as you say, it's going to be back and forth, and it's an iterative process, as they say.
I think that's right, and I think I wouldn't take this if I was advising a buyer. When I do advise buyers, I would not take this decision as just simply giving them carte blanche to in any way not strive to set out their loss correctly. I think it's really important in this type of case at the notification stage, not the day before the final date for notification, but in good time before the time limit runs out, to sit down with the legal team.
Yeah.
If it's a substantial case, to get counsel involved, to get accountants involved, and work out how the loss can be calculated, because it's obviously absolutely critical in these type of cases to present a robust, legally justifiable claim.
Yeah.
And when you get accountants on board, they can add a lot to the picture here. They can bring a lot to the table, because when they're specialists in this field, they are very good at building up loss claims.
Yeah.
And I know sometimes they talk of accountants being the modern alchemists, and I know people say a lot worse things about lawyers, but they can really bring a lot to the table and indeed help you to build up as a buyer a substantial claim, properly calculated in accordance with the law, but really to present something formidable to the other side, get it as robust as possible. And that's really important, particularly where you're dealing with claims that run into the high six figures, seven figures.
Yeah, no, I mean, I think that's obviously it's safest to get it right first time. Drax, to prevent them having to go through all the way up to the Court of Appeal, if only they had simply, as you say, taken a little bit of time and got it right first time. Well, David, that's been really interesting. Thank you very much for coming in and helping put this together, this podcast. I will see you back here soon, and it'll be really good to have a further discussion.
Thanks so much, Robin.
If you have any questions, please do contact me at Collyer Bristow. Thank you very much.